to today's HR Bootcamp webinar on managing your employees. It's great to see so many of you joining us today. My name is Isabella and this is my colleague Tanya, and together we're part of the advice team here at EmploySure.
Our aim as advisors is to provide our clients with the support they need when they need it. Our main focus is to provide advice in line with legislation, so as to ensure our clients avoid any nasty surprises in the future, all whilst keeping in mind what they want to actually achieve.
While we wait for more people to log into the webinar, we'll just run you through a few of the main features of the webinar platform so that you can get involved in all the action. Firstly, to submit any questions, click on the Q&A widget. Tanya and I will answer these questions towards the end of the webinar. Secondly, the webinar comes with a free toolkit. The toolkit covers all content from today's webinar, so we encourage you to download it. You can do this by clicking on the resource widget.
We are also offering a free face-to-face meeting with an EmploySure representative who will personally visit your business and check for areas of non-compliance. To book this in, please click on the meeting widget. Finally, if you experience any technical issues, please try refreshing your browser. If the issue persists, send us a message through the Q&A button and a member of the team will help.
Every employer knows the value of good staff. A good employee has positive flow-on effects to every other aspect of the business. Things like culture, productivity, and therefore profitability and customer experience also have a good effect from having great staff. Today we'll guide you through the employee life cycle in 3 parts. Part 1, we will be discussing hiring and onboarding. In Part 2, we'll cover the ins and outs of performance management, and Part 3 is all about resignation and termination. Let's begin with a quick poll question. So the question is, how regularly do you update your employment contracts? A, after substantial amendments to an employee's role, entitlements, wages, or legislative changes. B, once a year. Or C, never. We'll return to your answers shortly. So starting today off with hiring and onboarding. Retaining staff begins with the contract. This is a great opportunity for businesses to set themselves apart from others and also set out what they require from the employee. Tanya, what are some tips you can offer businesses to have a strong contract when someone starts with the company?
So one suggestion is to try and ensure that the contract actually reflects what the agreement should be. A contract has a legal purpose. This is by far the number one function of a contract. But present it well. So make it easy to read and understand so that there is no confusion as to the intention and the employee's entitlements.
So Tanya, what advice would you give our viewers today in regards to verbal contracts?
So verbal arrangements or handshake contracts are a tempting proposition for our small business owners. Some employers feel that they don't want to use formal contracts because they think their business is too small for that. However, this seemingly informal and straightforward arrangement is in reality legally binding and something that might come as a shock to some of our viewers today. Nobody wants to think about the worst case scenario, but if a dispute arises and the employer only has a verbal contract to rely on, court proceedings can get very messy and costly. From a legal perspective, a written employment contract provides employers with a safety net and a foundation for the employment relationship. It provides a reference point for owners to return back to in order to resolve any disputes arising around rights, duties, other promises and arrangements that had been made. It also equips them in the event of a dispute or a claim.
So Tanya, what would you suggest to employers to make their contracts different?
So on your screen, you will have examples of what you would typically include in the contract. Things like name, start date, job title, number of hours worked, confidentiality, and intellectual property provisions as well. Really emphasize what your company is uniquely going to be providing your employees. And at this point, you want to be going above and beyond for your new hires, showing them how much they already mean to your business. And don't just describe your perks, design the look of your contract as well to potentially resemble what your company is about and what the company is trying to be.
Excellent, thanks so much Tanya for those suggestions. Now going back to our first poll question, Let's have a look at the results. So the question was, how regularly do you update your employment contracts? So 60.5% of you said A, 20.9% of you said B, and 18.6% of you said C. Well done to the 60.5% of you that update your contracts after any changes. Contracts should evolve with the business. However, it's important to note that any changes that you make to a contract must be done by mutual agreement between yourself as the employer and the employee. Now, since the employees signed the contract, they've been hired. It's now time for the all-important onboarding. I say important because a lot of unfair dismissal cases come down to the onboarding process in the business. The Fair Work Commission always looks at the quality of training provided to an employee and the induction into the company policies and procedures when dealing with any unfair dismissal cases. You have to make sure that you train your staff in tools and machines if necessary during the onboarding process and induct them in all the policies and procedures that are applicable to your business. For example, social media policies are a hot topic right now, so it might be something that you'd like to look into. Tanya, could you talk us through the key elements to ensure the best onboarding process for new employees?
Sure thing. I'd advise separating it into 3 steps. So step 1, before their first day, you want to advise your current staff of the new hire. So you want to let them know what their role is, their name, and if possible, appoint a mentor or a buddy to guide them through their early days. Before the new hire comes, make sure to prepare all the paperwork. So this includes tax and superannuation forms, potentially a company handbook as well. Make sure everything is printed and ready to go and ready to sign by the new recruit on their first day. If you use onboarding software, you want to make sure that it is uploaded and ready to go to be able to be reviewed and signed by your new recruit ahead of time. I strongly recommend appointing a buddy or a mentor where possible.
Yeah, like a buddy can always help a new employee's experience in their first days of employment and also helps them build new connections with other employees.
Exactly right. So step 2 is the hire's first day. Practical tips for an employee's first day is to give them a guided tour of the workplace and their environment, and of course training and induction into relevant aspects of their role. Also introducing them to the wider team if they haven't already had a chance to meet, perhaps through lunch or coffee. Step 3, after the employee's first day, it is important to maintain rapport and maintain records. So keeping the employee in the loop with regular reminder sessions or catch-up sessions, maybe a month or 2 into their employment. You can do this by having a blend of both casual checkups, follow-up meetings, and maybe even performance appraisals. During these periods, it gives the employee a chance to express any concerns that they might have and they might wish to resolve then and there. Following a basic plan like this makes a huge difference to an employee's experience and introduction into a new workplace.
I totally agree with you. I know that with EmploySure's onboarding program, it gave me a really good insight of the mission and the culture of the business, and it made me feel welcome straight away.
Exactly right.
So before we move on, I just want to discuss the importance of a handbook. The centerpiece of your onboarding program should be something like an employee handbook. The handbook, or a staff manual if you prefer, basically outlines the company's policies and procedures within the business. Strongly set out to your employees why your business exists and how it is different from others. With that, we'll move on to part 2, employees' performance. One of the ways you can stay competitive in your industry is making sure all your employees are performing at their best. Managing performance creates a more productive and harmonious workplace because your employees can really see the value of their own work. In a few minutes, Tanya will take us through some thoughts as to how to formally review or manage employees' poor performance. At an informal level, you can try a few simple fixes. You can perhaps start off by having a discussion with the employee's buddy to see if they know if there's anything that you need to be aware of. Or alternatively, you can take a proactive step as an employer and try and provide the employee with more training, more support in their role, more mentoring, or provide them with a written how-to list.
Or you could even just have those casual conversation starters. Hey, how are you? How are you tracking? And what can I help you with? Just as an icebreaker. So before I get to formal reviews, not all performance issues do require such a heavy-handed response. A simple chat, like you said, a written letter to the employee, they can all diffuse a situation before jumping straight into a performance management process.
In case you have tried your best and the employee is still not performing to the required standard, you may need to commence a formal performance management process. Effective performance management is really about knowing the exact problem that you want to address with the employee. Now, Tanya, I believe you have 3 systems you'd like to discuss.
That's right. So we'll go through the 3 most common performance management systems. You can outline these processes or systems in your handbook, by the way. And these systems that I'm referring to are 1, performance reviews, something that is your traditional way of performance management, 360 feedback, and management by objectives. So first, let's talk about performance reviews. So performance reviews are usually conducted annually and are a chance to meet with your employees and assess their performance. However, let's go that one step further and conduct performance reviews more regularly. Maybe even every 6 months and maybe quarterly or 3 months.
So why do you suggest these regular catch-ups?
So this way, rather than a review, it becomes more like a regular checkup. As an employer, you can keep better track of your employees' performance and feelings about the workplace. Another upside of having these regular catch-ups is that employees will feel more valued and their concerns acknowledged.
So to round off this segment, Tanya will go through 6 top tips for managing underperformance. These are stop and think, privacy, be specific, don't make it personal, ask for feedback in return, and try the big theory. Take it away, Tanya. Tell us more.
Tip 1 is stop and think. Simply decide if it is the right time to raise an employee's underperformance. Really take into consideration and notice the employee's emotional state and potentially that of the environment in the workplace. Time and place is a very important consideration, which does bring me to our next tip. Tip 2 is privacy. So don't discuss any problems in front of the employee's colleagues. This might be embarrassing and might even damage the relationships that they have with their colleagues. I strongly advise against doing something like this. Also, do not raise issues in text or email. Always have these conversations face to face.
Yeah, I really agree with that as well.
And not only is it good practice, but the Fair Work Commission doesn't look too kindly on poor communication manner when it comes to discussing workers' performance or even dismissal. Tip 3 is be specific. While it's important to balance it, including positive aspects that you want to discuss, you need to be very specific when sharing negative feedback. So really discuss a particular scenario in depth. Another thing as well is try to empathize with the employee. Nobody really enjoys these types of conversations, so make it easier for everyone just by acknowledging that you know what the employee's feelings might be and acknowledging how they might react as well to bad news as much as you possibly can. Tip 4 is don't make it personal. It's really easy for one-on-one feedback meetings to feel like an ambush to the employee in question. So at all times, keep the discussion about the professional conduct and performance. Don't try and bring in any other irrelevant aspects and stick to the problem at hand and be honest about it. Tip 5 is ask for feedback in return. Any interaction like this becomes uneasy and confrontational. Prepare that the employee might raise an issue with the concerns that you've raised and also try to defend themselves. So diffuse the situation and turn the meeting into a more outcome-based one and by simply asking questions like, what can I do to better support you?
Yeah, I totally agree with that. I guess if you ask employees what you can do to assist them, they might be likely to react in a better approach.
And the final tip, tip 6, is the big theory.
What's the big theory?
The big theory stands for behaviour, impact, and get agreement. It's a good process to use when having these talks. So talk about what happened and what behaviour you saw or heard. Then discuss the impact that this behaviour had on clients, colleagues, or work in general. Offer positive reinforcement to your employee and then come up with a plan on how to see the change that you need to see.
All those tips are really great, Tanya. Thank you for that. Before we move on to our final segment of the webinar, we'll just take a quick break to answer some of the questions that came through our Q&A widget.
So the first one that we've received is, do you recommend including policies in the handbook or posting these individually or on our internal intranet page?
So generally with this, I would recommend to have all your policies in one particular document. We need to ensure that it is easily accessible for all your employees and all the information is collated in one spot. The second question that we have today is, if an employee is performing badly at work but uses personal issues going on outside of work as an explanation for bad performance, can you proceed with a performance improvement plan?
So generally, we would commence some sort of performance improvement plan, but it is going to be taking into account that particular employee's situation and what they're actually raising as those personal issues. So it might not be appropriate, but it may be appropriate. It really depends on the employee.
And the final question for today is, I believe one of my staff is stealing from the tills. If I was going to dismiss the employee, would I need to pay them annual leave? I'm still confused on how to make the process fair.
So the quick answer is, unfortunately, we can't withhold money, especially relating to annual leave entitlements. However, there might be other things that we can withhold, and really depending on how we're dismissing them, perhaps we don't need to pay the full notice period.
That last question is a great way to lead into our final topic of today, resignations and terminations. So an employee's journey with the company will eventually come to an end. This area of employment is so important and is quite detrimental if done incorrectly. So it's important to understand your employees' entitlements and any relevant legislation which they need to be adhered to. So let's start with resignation, or when an employee voluntarily decides to terminate their own employment. Fill me in with the facts, please, Tanya.
So employers generally have no choice but to accept a resignation. So when given a resignation letter, an employer should take note of the notice period. As an aside, an employer can attempt to gently convince an employee to withdraw their resignation, or not accept the resignation where there is potentially like a grievance process on foot, or it was given in the heat of the moment. To know how much notice period is required by your employees, you should refer to the employee's award, contract, or other industrial instrument covering their employment. These things usually set out how much notice, if any, they are required to provide when they resign, and also whether an employer is able to potentially withhold any certain amount of money if they do not get the required minimum notice period from their employees. An employee can give more notice than required if they wish to, but an employer doesn't have to accept this and can choose to let the employee work only the minimum notice period.
So do notice periods apply to all employees?
Great question. No, they don't. If an employee is a casual or potentially a seasonal worker, they don't actually have notice periods. Another common situation where an employee doesn't have a notice period is one where they have been fired for serious misconduct. There are many more nuances, but they are very industry specific as well.
Thanks so much for that, Tanya. If you would like any industry specific information, please get in touch with EmploySure. You can do this by clicking on the meeting widget and someone will be in touch shortly. So are there any other obligations that an employer must meet when an employee resigns?
Apart from notice periods, another employer obligation is to make sure that payment is made in the required window. So usually 7 days, but this is specified in individual awards as well, from the employee's last day, and to make sure that they pay all the outstanding entitlements. An employee should get the following entitlements in their final payment. First one is all outstanding wages for hours worked, including penalty rates and allowances, any accumulated annual leave, and if it applies, annual leave loading, accrued or pro rata long service leave, and potentially redundancy pay.
So you say usually 7 days. What do you mean by this?
So like I just mentioned earlier, the window of 7 days may be actually specified in the employee's award, registered agreement or contract even, so make sure that this is checked first. If there is no time frame that's applicable, it is best practice to pay the final pay on either the employee's last day of work or their next scheduled pay cycle. In some cases, both you and the departing employee might agree in a written payment letter format to pay on a particular date.
So is there anything else that employers can ask from employees?
Absolutely. So when an employee leaves, you can request that the employee returns all business property, remove or return confidential work files, and reveal any passwords that they might actually have for their computers or any other workplace security measures.
Okay, great. Thanks so much. Well, I think that's all for resignation. Now, time to discuss termination. There are many reasons why an employer may feel the need they need to dismiss an employee. However, it's important to note that an employee still receives their minimum notice requirements. This notice period is a requirement under the National Employment Standards and as such must be observed by every business in Australia. The length of notice period, which you must provide employees, is based on the length of service the employee has with the business. If the employee has been working with you for less than 1 year, 1 week notice must be provided. Between 1 and 3 years of service, the notice period is 2 weeks. Between 3 and 5 years of service is 3 weeks notice. And finally, an employee who has been at your business for 5 or more years is entitled to 4 weeks notice. Tanya, are there any add-ons to this?
Yeah, Isabella. So there are 2 things that we need to consider with regards to notice periods. So one is if the employee's agreement or contract actually specifies a longer period for termination, then the employer must actually adhere to that. And 2, if the employee is over 45 and has worked for at least 2 years on the day that you terminate their employment, they are entitled to an extra week's notice. That's all. And this time it's quite simple and straightforward for calculating notice.
Oh, thanks for that, Tanya. Like many things with employment relations, ending an employment agreement needs to be done with the proper process. It is important that you implement the same process when the situation arises in your business. It is necessary to give the employee written notice on the day of termination through a termination letter. You can either give this to them personally or you can either post it to their home address. So Tanya, are there any tips that you can give our viewers on dismissing an employee who's on leave or on probation?
So many employers are confused as to whether they can terminate employees whilst their employees are on leave or in the probationary period. So the answer to that is yes, you are permitted to dismiss an employee whilst they are on probation. However, dismissing an employee whilst they're on leave may actually come with other considerations, and we would always need to consider them on a case-by-case basis.
That makes sense. Do you have any other final tips for notice periods?
So once you've given the employee notice of their termination and accounted for their correct period of notice, there are 2 ways to proceed. So one, you can choose to have them work through their notice period, or you can pay out the full amount of notice in lieu. So that means that they are not working out that period of notice. So payment in lieu of notice may include bonuses, loadings, allowances, penalty rates, and overtime, also depending on the award that covers the employee.
As we all know, dismissing an employee can land an employer in hot water. Employers have to get it right, as the Fair Work Commission has very dim views about employers who dismiss their employees in a harsh, unjust and unreasonable manner. So following the correct process is imperative to a business.
And that's right. So unfair dismissal cases are very common at the Fair Work Commission. It is critical that employers get this right. You must have a solid reason for dismissing an employee and be transparent and open about what that reason is with the employee. Some general advice is to discuss with an employee about any and all issues that you might have with them at any point in time. If your employees are underperforming, raise the issue with them and give them an opportunity to improve. Also, you must, and I can't stress this enough, you must be certain that your issue with the employee is not one that will be seen as discriminatory or against discrimination guidelines. So there are 12 characteristics that you can't discriminate against. These are race, skin colour, sex, sexual orientation, age, physical or mental disability, marital status, family or carers' responsibilities, pregnancy, religion, political opinion, national extraction or social origin.
Are there any other risks that employees should be aware of when it comes to terminating an employee?
So we've covered unfair dismissal and discrimination, but employers should always also be aware of adverse action. So this is a provision in the Fair Work Act that protects employees from basically being forced out of or singled out at work. Things like being treated adversely due to an injury, discriminating against employees for one of the reasons mentioned earlier, can all fall under the adverse action umbrella. Another risk for employers is to a bullying and harassment claim. Management action that isn't carried out in a reasonable way may be considered bullying by the Fair Work Commission. For example, warning an employee for not reaching unreasonable work demands is an example of bullying behaviour.
But as with most things with employment law, there are a lot of considerations. You can do everything right but still be faced with an unfair dismissal claim at the Fair Work Commission.
Unfortunately so. So I recommend two things for employers. Number one, and back to the very first topic that we covered, is to implement proper policies that you inducted your employees with in the very start of their journey with you. This will be evidence to take to the Fair Work Commission as well, if it does come to that you had a fair and reasonable process and that you followed it. And number two is get in touch with EmploySure, so we can assist in establishing the fundamentals that we've discussed, starting with your basic policies and your employee handbook.
So we've covered a lot of information today. Thank you for sending through all your questions. If any have been left unanswered, an EmploySure representative will be in touch with you in the next few days. You will also receive an email with the recording of today's webinar, so you can watch on demand.
If you're unsure or you're faced with a complicated situation, it is recommended that you contact a workplace specialist so that you can be confident in your actions and decisions. You can contact the team on 1300 832 795.
Thanks so much for joining us today. Today was our last episode of our HR Bootcamp, but we hope to see you again in the future.